Welcome. I think it's a testament to the quality of this panel that all of you are here on a Saturday afternoon. So thank you for sticking around, and I think you're in for a treat. We are going to, in fairly short order, try to make sense of the Roberts Court's First Amendment jurisprudence and try to figure out how the court upholds the rights of lunatic funeral protesters, aficionados of dogfighting, corporations, but not people who tried through benign means to persuade terrorists to give up their arms. I anticipate, I'm going to try to work in a lot of First Amendment cliches. I anticipate a robust and wide open debate, and I see my role as enforcing time, place, and manner restrictions only. Along those lines, I'm supposed to tell you several things. If you want CLE, this plenary session is eligible for CLE. You sign in at the desk outside the room, you pick up a certificate of attendance, and you fill out an evaluation form and submit it to the CLA table at the end of the discussion. Our commitment to the First Amendment is not total. We're not going to take questions from the floor, but we will allow you to write down questions and sift through the non-offensive ones and ask those. You should please turn your cell phones off. So let me introduce this panel, which is really fabulous. I'm going to start down on that end with my old friend Floyd Abrams, who is a partner at Cahill, Gordon, and Reindell, a giant of First Amendment law, has done more to shape press law in particular than any other advocate in the history of the Supreme Court. He has, I should say, represented the New York Times often. You may be interested also that he represented Senator Mitch McConnell on the winning side of the Citizens United case. Monica Youn is senior counsel at the democracy program of the Brennan Center. She was co-lead counsel on what will be the next 5-4 campaign finance decision, McComish against Bennett. And although it's not in the bios, there are much longer bios in your materials. I think you should know that she is also was a finalist for a National Book Award for her poetry. Oh. Paul Clement is, it's a little bit of a surprise to have him here because he's the busiest lawyer in America. A former United States Solicitor General. He currently, at a smaller firm than one he recently left, represents the House of Representatives in its defense of the DOMA statute, 26 states in their challenge to the health care legislation, Arizona in its defense of a controversial immigration law. If Wikipedia is to be believed, he turns 45 next week. I don't know how he does it. He was also on the winning side of McConnell against Federal Election Commission, which he argued in the Solicitor General's office. Nadine Strossen is, I'm sure well known to all of you, a law professor at New York Law School, and from 91 to 2008, she served as president of the ACLU, the first woman to head the ACLU. Bollinger is president of Columbia University and has written widely and thoughtfully and deeply on First Amendment matters. And of course, Judge Berzon on the Ninth Circuit is well known to all of you. She's served with distinction on that court since 2000. So moving to substance and setting the table, and I'm eager to have a conversation about these issues and to try to find some themes. Maybe let me start with you, Nadine. In just a minute or two, how do you characterize the Roberts Court's First Amendment jurisprudence? Does it cohere?
It coheres in a way that Justice Thomas explained when he was dissenting in one of the controversial Roberts Court's decisions, Morse versus Frederick, which purported to uphold the court's general protection of free speech for students, except there was a whole laundry list of exceptions, to which this case added another. And Justice Thomas said, the court's jurisprudence adds up to this, that students have free speech rights, except when they don't. And I would say that is an extremely good summary of not only the jurisprudence with respect to students' free speech rights, but also in general. And one footnote, which I mentioned to Adam beforehand, I think most of the generalizations I'm making are not peculiar to the Roberts Court. I think, you know, a lot of the cases that Justice Thomas was referring to went back to the prior court. That said, the charge for this fascinating panel was to focus on the Roberts Court specifically, and I really welcome it because it gave me a very different view overall than I had had. Adam, not surprisingly, listed the 3 blockbuster cases that I think everybody associates with this court, protecting what many people consider to be controversial speech, and therefore one correctly says, well, in those 3 instances, the court enforced a very robust, strong sense of speech and very narrowly limited the government's power to restrict speech. But when you step back and look at the overall pattern, as I did, all of the decisions in the 6 terms, and we're only partway through the 6th term, the pattern is really much more negative for freedom of speech. In every single one of the terms that has concluded, the free speech losses outnumbered the free speech gains. And the total record, the free speech losses outnumbered the wins by more than a 2-to-1 margin, 70% to 30%. And by the way, even the court rules in favor of the free speech claims in the 3 remaining major cases this term, there would still be an enormous discrepancy over the entire period. Moreover, of the 15 cases out of 21 in which the court rejected the free speech claims, the lower courts had upheld those free speech claims. Now, to be sure, a lot of those lower court decisions were from the 9th Circuit, Judge Berzon's court, but putting the stereotype aside, many of those decisions came from many other circuit courts. Now, let me tell you something else interesting about the patterns here. One is that if you consider the total of 6 cases in which the Supreme Court has upheld the free speech claims during this period, 4 of them, Monica probably knows this very well, 4 of them involved challenges to campaign finance restrictions. So a full 2/3 of the free speech victories were in the area of campaign finance. And then conversely, if you look at the 15 cases in which the court rejected the free speech claim, there are a number of other striking categories. Most strikingly, more than half of the free speech losses were cases in which the plaintiffs were public employees, public employment unions, or students at public schools or universities. So you put those 2 patterns together and you see the overwhelming majority of free speech victories strike down campaign finance regulations that at least the proponents hope will bring about equality, and conversely, more than half of the free speech losses spurn claims that are brought by individuals over whom the government has an enormous amount of power. So this is consistent with a theme that Professor Kathleen Sullivan developed in a superb article in the Harvard Law Review last year, that the court is emphasizing libertarian values when it enforces freedom of speech and de-emphasizing egalitarian values. Just 2 other observations about patterns into which the free speech losses fall. One is the court several times has upheld mandatory disclosure rules against the argument that that constitutes a burden on speech, chills free speech. And that's kind of interesting because I think on the whole we're seeing more and more, and we'll continue to see more and more conflicts between values of privacy versus values of free speech, and the court seems to be oriented toward the free speech end of that spectrum. The second major additional pattern I wanted to signal was a cluster of cases, 3 cases in which the court says that the speech is in essence an integral aspect of criminal or unlawful conduct and therefore allows it to be suppressed That said, the court has been very inconsistent in doing that in the famous depictions of animal cruelty case to which Adam referred, in which the court upheld free speech claims. Precisely the argument that was made by the defenders of the law was that this expression should be seen as an integral part of criminal conduct, yet the court rejected the argument in that context. So I'm going to end where I started by talking about the inconsistency of the court's rulings, not only in terms of who wins or loses, where if you're going to count just by the numbers, free speech loses more than it wins, but also in terms of the analysis that the court uses. Sometimes it is very hostile to facial challenges. Sometimes it's receptive to facial challenges. Sometimes it uses strict scrutiny and enforces it strictly, and sometimes it pays lip service to strict scrutiny but is in fact very deferential to the government, and in fact it uses a whole host of ranges of scrutiny. So to conclude where I started, full circle, a very well-known line that was used in one of the campaign finance cases was by Chief Justice Roberts when he said, in a case that implicates the First Amendment, the tie goes to the speaker, not to the censor, and I would say, except when it goes the other way.
So, Paul, does that account of the Roberts Court and the First Amendment sound right to you? Incoherent and hostile?
Well, that's not how I'd put it. But I think part of my role here is the advocate's perspective. So, the advocate's not going to put it that way. I think if you're trying to address the question, does the Roberts Court have a coherent approach to free speech? I think the first thing you have to do is you have to separate out the campaign finance cases. Because for better or for worse, in the campaign finance world, the Roberts Court has a very coherent approach, which is almost all of them violate the First Amendment. And I mean, just to kind of put it in slightly autobiographical terms, but I think it makes the point, my term in the SG's office spanned the end of the Rehnquist Court and the beginning of the Roberts Court. In that time, I argued 5 campaign finance cases, actually more than terrorism cases. So, it's an active docket. I won every case I argued in front of the Rehnquist Court, and I lost every case I argued in front of the Roberts Court. So in terms of the Roberts Court and campaign finance, I think it's quite coherent. I think there are 5 justices that believe that campaign finance laws are subject to the strictest of First Amendment scrutiny, and we all know what happens most of the time when a law is subjected to strict First Amendment scrutiny. And I don't think that that's going to stop. I mean, if you look at the Roberts Court more broadly, in so many areas of the law, there's sort of 4 justices on one side, 4 justices on the other, and Justice Kennedy is somewhere in the middle. On the issue of the free speech when it comes to campaign finance, Justice Kennedy's not in the middle. I mean, he's leading the charge to try to be, a First Amendment hawk when it comes to campaign finance. So there I think you find coherence. Separate that out and look at the rest of the cases. I think you won't find the kind of coherence that's going to appeal certainly to a clean academic mind. I think, but in a way I think maybe it's asking too much, because if you look at the Roberts Court First Amendment speeches, probably the strongest prediction you can make about a First Amendment case in the Roberts Court is that if the Chief Justice writes the majority opinion, Justice Alito's likely to write a separate opinion taking a different tack. And in a lot of cases that's been sort of less hawkish on the First Amendment, Snyder and Stevens, but in other cases it's been more protective of First Amendment values, and there I'm thinking of the Morse case. So in an area where the 2 Bush 43 appointees seem to be taking diametrically opposed views on some of these issues, I think maybe asking for coherence is a bit much. But let me finish by saying I do think that, again, from an advocate's perspective, I think if you look at these cases, there is at least something that an advocate can pull away as advice to how to try to win one of these cases if you are advocating on behalf of the First Amendment, the pro-First Amendment side. And I think one thing that sort of distinguishes the cases where the First Amendment side wins from where they lose is whether you convince the court, and in particular the conservatives on the court, whether you convince them that this is a real or pure First Amendment claim. If you can convince them that this is really the government acting as sovereign, restricting speech directly, then you will probably win no matter how outrageous the speech is. see Snyder, see Stevens. On the other hand, I think the game for the government advocate generally, defending the law against a First Amendment challenge, is to try to say, no, this isn't sort of a classic government as censor situation. This is different. This is public employees. This is legislatures and their votes, and that's not real First Amendment activity. Maybe this is, like I said, there's the public employer context, the school kids context. There's something else going on here other than the classic First Amendment context. And I think if you're looking for a coherence, at least at the level that can appeal to an advocate who's trying to win the case, I think the game, in many respects, is to try to push the case into the category of a pure First Amendment case, or out of that category if you're the government advocate trying to defend it.
Okay, so we've heard somewhat clashing versions from, call it, an academic and an advocacy background. Let's have a judicial perspective. What do you think, Judge Berzon?
Well, from a judicial perspective, I tend to look at the cases in terms of what do I do next as a judge? What I learned from the last 5 years of First Amendment cases, and I think that on a doctrinal level, which is how I look at it, i.e. my next case isn't going to be the last case, it's going to be another case, and in another case I'm going to look to the case law to see what I can pull out of it, not to apply its holding. And looking at it that way, I think that the incoherence vastly predominates over the coherence. In particular, I try to figure out what I would do if I was faced with a facial challenge versus an as-applied challenge. How do I decide which one to apply? I found out in Citizens United that basically it's only about remedy, so you can do either one. It doesn't matter what's being argued. And then I found out in some of the other cases that if they haven't argued something particular, then we absolutely should not be deciding it. That's the Christian Legal Society. And in Doe versus Reed, on the other hand, they did a facial, which is the petition case. They did a facial challenge and remand for an as-applied challenge. So therefore, what am I supposed to do next if somebody comes in and makes, for example, an as-applied challenge, but I think there's really a facial challenge which would solve the whole problem and people wouldn't keep coming back to me? Probably do what I want because that's what the Supreme Court seems to be doing. Then there was I was actually fascinated reading through these cases how many times the government was arguing for a categorical exclusion from the First Amendment, which I think is something new. I don't think that's happened. It hasn't been a popular argument, but it seems to be a popular argument now. And what happened there? Well, in Doe versus Reed, the petition case, they said absolutely not. There's no categorical exclusion. In Stevens, the animal cruelty video case, they said, oh, this is really dangerous stuff to be arguing for categorical exclusions. In Williams, they said there's a categorical exclusion for offers to engage in illegal activity, and in Nevada, they said there's a categorical exclusion with regard to legislatures' votes. That's not speech. So this very dangerous operation, nonetheless, seems to have been accepted twice out of the 4 cases in which I saw it raised when I was going over the case law. Similarly, and this was quite predominant, on the question of whether you construe a statute to avoid a constitutional issue. The answer was maybe. It depends. It seems to depend primarily on whether you think the First Amendment argument is actually worth something or not, or something that you really care to avoid, or something that you care to reach. So if, for example, in Humanitarian Law Project, the material support case, Justice Breyer offered in dissent what seemed like a pretty plausible statutory interpretation, which would have avoided the issue, and the court said absolutely not. This statutory interpretation can't be reconciled with this subsection and that word in the statute, and so on. In Milovitz, which was a case about the bankruptcy code and whether preclusion on on advice by lawyers in contemplation of bankruptcy, the court decided that contemplation of bankruptcy meant specifically the kinds of abuses associated with telling people to incur more debt before bankruptcy, as if that was somewhere in the statute, which was a little hard to find when you were looking at the statute. So again, the answer to that seems to be sometimes. Similarly, Citizens United there were some very forceful statutory construction arguments made, which the court said couldn't be reconciled with the statute, but ultimately said, particularly when we're convinced in the end that this corporation has a constitutional right to speak on this subject. In other words, we want to reach the constitutional question, so we'll do it. Let's see. Finally, the other thing that struck me reading through the cases was what I would call doctrinal bleed. That is, I'd be reading through something, and all of a sudden I'd encounter an idea that I thought came out of one set of these variegated set of First Amendment cases, and there it was in the middle of something else, where, as far as I know, it had never been before. And for example, in the Snyder case, which was the funeral picketing case, all of a sudden, the whole premise of that was a distinction between whether this was public speech or private speech, and it was written as if that was an overriding First Amendment categorization. It is a categorization that's used in the employee cases, and it's used in the defamation cases, and maybe they meant to be putting it into that this was a tort case, and maybe that's what they meant to be saying, but they wrote it as if it applies just over, in general, and over the larger categorization. With regard to the standard of review, there were all sorts of phrases being used and standards being used. We had the Humanitarian Law Project. They rejected the O'Brien conduct case and said we're going to apply a more demanding standard. But what that more demanding standard exactly was, nobody ever exactly said. And in Doe, the picketing case, they said that they were going to apply exacting scrutiny. This is a new phrase, exacting scrutiny. It's not strict scrutiny, it's not intermediate scrutiny, it's exacting scrutiny. And what that exactly is wasn't so plain either. So what we have is a situation from the point of view of an intermediate appellate court where you can pretty much find what you want if you're looking for it. And therefore, the constraints in terms of what's supposed to happen in the next case are pretty hard to find.
So I think maybe part of the reason we find it so confusing to look at is because it's not clear anymore where the left and the right stand on these issues. I feel like when I was in law school, the basic idea was that progressives were in favor of a vibrant market for political dissent, lots of political speech, maybe not wholly the case anymore. And let me put it this way, Floyd, why is everyone in this room so mad at you?
I really don't understand why. But I guess that there are some causes, some other social interests, you might say, which persuade people that First Amendment arguments that they might otherwise accept ought to be put to the side. And in the campaign finance area in particular, that's always been one of the conflicts here. I mean, it seems to me whatever one thinks of the area, the First Amendment argument of Justice Kennedy that this is political speech, and my God, it's political speech about who to vote for, no less. That's got to rank at the top of the First Amendment side of the equation. What you put on the other side of the equation, how seriously you take it, the degree to which you think, the circumstances in which you think that other interests, whether you categorize it narrowly in terms of fair elections or appropriate elections, or the ability of the public to get money, which is a potentially at least distorting element out of elections or to minimize it, whether interests of that sort are sufficient to overcome the First Amendment interests is, to a great degree, what has divided the Supreme Court. But what I have found interesting and from a personal point of view, disturbing, is the reluctance of people who care deeply, passionately about the First Amendment to acknowledge the seriousness, the centrality, indeed, of the First Amendment interest on the side that those conservative jurists thought was so important in the campaign finance cases.
Monica, you acknowledge that interest, do you not?
I do acknowledge that interest. I did promise Adam before this that this was not going to turn into a debate about Citizens United, and I don't want it to be. I think what's interesting about looking at this term as a whole is that Citizens United and the views expressed there are not even a good predictor of what the court's going to do in campaign finance cases. Because if you read Citizens United, it puts forth, a vision, a fairly coherent vision of more speech is good, no speaker-based discrimination, etc. And then if you look at what the court is actually doing in cases like the union cases, where they're arguably upholding rules that will result in less political speech, and rules that arguably have entirely the purpose to suppress political participation by unions. And also, if you look at the two of the what I call the subsidy cases, the Davis Millionaires Amendment case, and also the pending McComish case, where I think the court has signaled where it's going pretty clearly. Those are also governmental rules that will result in more speech and subsidized speech. And having those struck down by the having these speech restrictive rules upheld by the same court that decided Citizens United, and having the speech subsidizing rules struck down by the same court that's upholding government speech across public forum cases such as Sumim, etc., is just really, it's impossible to understand it as coherent.
Can I add one other contrast, which I agree with what Monica has said, that Citizens United, one of the very strong, seemingly absolute pronouncements the court is making there is that it is going to very strictly scrutinize any speaker-based or source-based restriction, i.e. flowing from the identity of the speaker. And in that case, of course, it's saying we're not going to separate out speech by corporations or unions for unfavorable treatment. But then you shift gears and you look at not only the public employee and public union cases, which Monica mentioned, but public school student cases and prisoner speech cases, and the court comes up with a seemingly ad hoc justification in each situation to say, well, we're not ruling against the speech in general, but when it is prisoners, when it is students, then we will defer to the government. So it seems quite results-oriented.
Lee, what do you think? What are the prisms through which the court looks at these issues, and what should they be looking through?
Well, I think from my standpoint, as I read through these cases, I see a number of things that I find troubling. I think, first of all, I would say, I think the First Amendment is doing well. I don't think we're in a period in which the framework that was laid down primarily in the 1960s is under threat. What I think is happening, though, I think there are 3 or 4 things that I would mention. I think one is that in certain areas like school, high school student speech, and public employee speech, you find that the basic case, the Tinker case, the Pickering case, those cases are reaffirmed, but then there's a new exception created. So that I think one would expect over time to have the great cases continue to be affirmed, but more exceptions. The second thing I feel is that the theme in the First Amendment that went for several decades and really reached its peak in the 1960s and then partially in the 1970s, in a kind of mixed, because the First Amendment's a very complicated jurisprudence. It doesn't have just one theme in it. And one of the great themes, I think, reflected in cases like Red Lion and the broadcast regulation area, is a legitimate concern of the government with quality. And the Citizens United, I think, is an emphatic, in some other cases as well, rejection of that broad kind of theme that we would essentially saying we will never let the government be involved in trying to think about the quality of public debate. I mean, after all, fairness doctrine, local reporting, a number of things were upheld, and I realize it's complicated, but I think that was a basic theme. I think a third problem is what I would say is the kind of technocratic, bureaucratic, almost sterile, highly qualified affirmations of free speech and free press. And I think that's a pity, and I think it's a pity because we're really dealing with a very great achievement, I think, of the United States that was formed in cases in the 1960s and then in the early 1970s, drawing on the great cases of the 1920s, the great opinions. And that created this value in American society that is unique in the world, and it's unique in I think, human history. And it's a commitment that has all kinds of meanings to it, but it's profoundly important. And what I sense in the opinions, even when they uphold free speech fairly strongly, like in the Westboro Baptist Church case and in the animal cruelty case, is a highly, get this as narrow as we possibly can, and do not explain to the country or to the world why this is a great principle for the society. Which leads me then to say that I think Alito has the most powerful opinions in those cases because he really highlights the harm of speech, of free speech. He really presses it on you, and it calls for an answer by the majority, and it's not there, and that vacuum is I think, serious. And the last thing I'd say is that there's just no sense in any of the cases, but especially the Holder case, Humanitarian Law Project, where you would expect it to sort of begin to emerge. There's no sense that we have moved from a national kind of public forum into what is clearly a global system with global issues, global communications, and how the government, the US government, affects that global public forum, I think is now of profound significance. And you look at the cases and it's as if that doesn't exist.
Mm-hmm. So speaking of those transformative cases from the 60s and early 70s, Floyd reminded me that it's the 40th anniversary of Judge Gerfine, the Southern District judge who got as his very first case, the Pentagon Papers case, Judge Gerfine's refusal to enjoin the publication of the Pentagon Papers. And Floyd, of course, acted as co-counsel to the New York Times in that case. And I want to explore for a second where national security fits into this analysis. And starting first with the Holder case, and Paul, I know you litigated lots of national security cases. Am I right in thinking that whatever else can be said about the court where the interest on the other side is national security, the First Amendment claim is likely to lose?
Well, I think if there's national security on the other side of the balance, then you are going to engage, I think the court is going to engage in a greater degree of balancing than you would expect. I mean, generally you think about First Amendment cases, and if you're in strict scrutiny at least, there's a notion that there's some balancing that's supposed to go on, but you really don't expect it to make any material difference in the end. And I think if you do have national security as the compelling interest to weigh in the case, then I think you're going to find that unlike most First Amendment contexts, there really is going to be kind of a meaningful struggling to try to get the balance right in those contexts. And I think the court, one of the things that really struck me about that case in particular was that it was not 5-4, that it was 6-3, and that Justice Stevens, because I think in large measure because of that context, I think he saw that differently from the way that I think a lot of us might have predicted that he would see it. I also thought it was, you think about the Schneider against Phelps case, and you think about it being an 8-1 case. It's really not. It's an 8-2 case, apparently, because Justice Stevens,
he's still voting.
Right. No, and apparently he felt for Justice Alito, felt he was a little lonely out there, and kind of weighed in on that side, which of course brings to mind the flag burning cases, which are cases where famous cases where he was famously in the dissent. And so I do think that certainly for individual justices and probably for the whole court, when you get kind of national security into the mix, they are going to look at the cases differently.
What's so surprising, Paul, is that in other national security cases, the majority, including Justice Kennedy and then Justice Stevens, refused to defer to the government, to be sure, to the great consternation of the dissenters. But why did the court not defer in Hamdan, Hamdi, the military commission cases and the detention cases, and yet be so deferential with respect to freedom of speech? I found that very surprising and and dismaying.
Well, it's definitely an interesting sort of contrast, and it's one area where I think the order of the cases may have had an impact on how at least some of the justices, not all of them, I think lots of them would have voted exactly the same way no matter what, but I think the order of the cases may have had an impact because the court had had so many cases about enemy combatants and what that system was going to look like before they got a case like Holder. And the Holder case, the Humanitarian Law Project case, is, on the one hand, it's a First Amendment case, but it's also a case about how the Article 3 system is going to be used to criminally prosecute terrorists. And it comes up in the context of the statute that the government is using more than any other statute to prosecute terrorists in the Article 3 system. And I sort of wonder if all of those enemy combatant cases that got the court sort of thinking that, well, we're not that sure about this system and the Article 3 system is the preferable system, whether that didn't give at least some of the justices a sense, all right, we've talked about the Article 3 system as being kind of the better alternative. We better make it a workable alternative, and we better not strike down the material support statute, which is kind of the workhorse of that Article 3 alternative.
I'm really struck in listening to thinking, Adam, what you raised earlier, when you talk about Holder and you think back to 40 years to the Pentagon Papers case, if the court in that case and Pentagon Papers had really thought that the level of deference to the executive branch was anything like what the Holder court says, we would have lost. And I should make clear, we almost lost. People forget. That's a 6-3 opinion, with some of the 6 saying we agree that there's likely to do substantial harm, but even so, it's a prior restraint case, so the government hasn't quite cleared the barrier. Now, the barrier there was persuading the court to overcome the presumption, the strong presumption against the issuance of a prior restraint. You only overcome it on facts. It's not a legal analysis anymore. You overcome it by persuading the court, the government, by persuading the court that the harm will be so substantial, so immediate, so inherent in the situation that you simply have to agree to issue the prior restraint. But listen to the court in Holder when the court says it's perfectly true that we're not giving up our juridical role. We're not giving up our power, the courts, the judiciary, to decide what the First Amendment protects and what not. That's the legal side. Then they say, quote, but when it comes to collecting evidence and drawing factual inferences in this area, the lack of competence on the part of the courts is marked, and respect for the government's conclusion is appropriate. Now, that's perfectly rational, arguable a position to take. But if you really mean that, if you really mean that there's going to be a high degree of deference to the government where it makes national security claims, then it does put at issue, it puts at risk, I would say, victories for the First Amendment in cases such as the Pentagon Papers, where after all, our side, the Times, was arguing, oh, look, Judge, there's nothing more recent than 3 years, nothing within 3 years of 1971. Lots of it has been published already. None of it is really that important. Now, we failed, people forget, we failed to persuade the court that we were really right on that. When you count the votes again, more people thought harm would occur than not. But they weren't persuaded enough, as I said earlier, of the imminence, the inevitability, the unavoidability of the harm. So the critical votes of Justices Stewart and White fell our way. But if they'd been viewing it through this prism, and perhaps they still won't in a prior restraint context, if they'd been viewing it this way, they might not have gone our way. And if you want to posit the next series of potential cases under the Espionage Act, where we're talking not about prior restraints but criminal punishments, then all the added protection that the First Amendment received because it was a prior restraint case fades away, and language such as this is particularly worrisome.
Can I throw in a reference to another clause in the First Amendment that came to my mind, and I was disturbed for yet another reason about the Holder reasoning, where the court stressed the fungibility of any kind of support. So even the ACLU represented a number of organizations, including the Carter Center, Human Rights Watch, that were strictly engaged in peaceful advocacy and yet came under the very broad, vague language of the statute. And the Supreme Court said even innocuous support to even peaceful, nonviolent, lawful activities can be fungible and be siphoned off by this terrorist organization into terrorist and violence and unlawful activities. That is the exact same argument that this court has very strenuously rejected with respect to the Establishment Clause, that money that is earmarked for the ostensibly non-religious undertakings of even purely sectarian organizations, such as parochial schools, the court has rejected the argument about the fungibility of money and purported to say, well, you know, we can allow the government to finance the educational aspects without falling afoul of the Establishment Clause. So I'm sorry, I guess I like your summary, incoherent and hostile.
Well, what you might say on behalf of Holder is that the Chief made very clear that independent speech is unaffected. It's only coordinated speech. So there's a kind of Citizens United through line there, too, between independent speech and coordinated speech. But let me ask you, Lee, if a Pentagon Papers-like case arrives at the court today, and if technology makes it a little hard to imagine, actually, that you could have an effective prior restraint, but if some version of that, let me throw out the word WikiLeaks, some version of that arrives at the court, do you think this court looks at it very differently than the court of 40 years ago?
So I really don't know the answer. And I think about this, of course, a lot. I mean, I think conceptually, we are just not, the First Amendment seems to me to be kind of stuck. And it's not being progressive, and it should be. Of all the things, of all the parts of the Constitution and the society that ought to be moving our sort of understanding of how the world is going, how discussion and speech and information is part of that, it ought to be the First Amendment. And here we are in a new world in which we are completely integrated into the world economy, we're completely integrated into a world technologically with communications. The issues are global. We can't solve them anymore ourselves. Climate change, economic regulation, whatever it is. And we are now dependent, our citizens, our system is dependent upon how people are informed and think in other societies. So I don't know that the PKK ought to not be declared a terrorist organization, but the court ought to be responsive to a kind of global sort of sense of flows of information. I mean, this is a whole new thing, I realize, but it was the perfect case, it seems to me, for introducing that idea. With WikiLeaks, we have another sort of example. So there are 2 or 3 things that are very different now from Pentagon Papers. One is the ease with which information can be released. So it's one thing to go to a Xerox machine and plow out 47 volumes. It's another thing to push a button and have 500,000 documents suddenly available. Secondly, we lived in a world where the press was the primary recipient of leaks, and that was more or less a monopoly and had developed professional standards and expertise and so on, but you could count on it to behave responsibly. I mean, I think that's a very, very important situational fact. Now, and patriotically, by the way, I mean, to use a word that's not very commonly used in these kinds of settings. And there, now we have people who have no interest in sort of the values of American society necessarily, receiving huge amounts of information. And the risks, I think, go up. Whether that's sufficient or not to change the balance of Pentagon Papers, it wouldn't be for me, but it may well be for this court.
And in
Can I
fairness,
give
back
one
then-
example? WikiLeaks received 91,000 of the many hundreds of thousands of documents that they've gotten, but 91,000 were American military reports in Afghanistan, written by American servicemen. They released 77,000 of those documents pretty much, well, very quickly, and initially withheld the other 14,000. Of the 77,000 that they released, they had read 2,000. This is what Mr. Assange said, and not just about himself. He and his colleagues had reviewed, read, studied, devoted any attention to only 2,000 of the 77,000. His defense of releasing it was there was good reason to think that there was nothing in the 75,000 that could threaten anyone's life, unlike, I would add, over 100 Afghan informants to the United States who were named in the ones that he did release. This is so far from a journalistic model, releasing 75,000 documents you haven't read, that I think, now I come back to what Paul started with, viewing this as an advocate. I see an advocate in front of the court someday in a case like this, overwhelmed by questions of this sort, which amount to nothing more or less than why in the world should we protect these people? Now, that's not the way the First Amendment is supposed to go, and this is a court that has already made very clear that in certain examples, which we talked about, I mean, terrible, terrible films, animal cruelty films, the awful Snyder speech. But that speech hurt in one sort of way. When you now transform this into the national security area, and the government comes to court and says, we can't function anymore the way we have to be able to function, if 250,000 cables can, with impunity, diplomatic cables, be furnished to WikiLeaks and at their will made public, I fear that all of the First Amendment arguments that we may make and all of our citations to past First Amendment cases may well come up short, which is just a way of saying, for that reason alone, I hope they don't prosecute.
Well, as Oliver Wendell Holmes, among others, has said, you know, history is worth a lot here too, and what we learn from history as well as the present is the government's propensity, no matter which major party is in power, to overclassify, to overbrand as secret information that turns out not only to be vitally important to we the people about policies that are being carried out in our name, but when push comes to shove and the documents are declassified, it often turns out, as Justice Douglas said in his opinion in the Pentagon Papers case, that the government has no legitimate national security claim. It's merely trying to protect itself politically and from shielding itself from embarrassing information. So given hundreds of thousands of documents, am I willing to assume that just because the government asserts that there's a national security interest there that we should defer to the government? I'd have to say respectfully no, Floyd, based on history.
But let me ask you, Paul, both Floyd and Lee seem to be pointing to a distinction that I think they would both say has no force in the law, but may have great practical force, is that even though they may not love the New York Times and other news organizations, at least they are quasi-trusted intermediaries who might be thought to have some patriotic values in addition to other ones in what they do, whereas Julian Assange may not. Does that figure in the legal analysis?
Well, I mean, I think Floyd and I have the exact same instinct, which is from the advocate's perspective. I think that's exactly what I would put my finger on, and that, you know, if I were trying to distinguish, you know, it's a tall order for any advocate to try to, you know, get around the Pentagon Papers. I mean, you know, it is like Tinker, it is like Pickering. It's, you know, even more so, I think. It's, you know, it's a towering precedent in the law. But if you're in a prosecution context and not a prior restraint, that helps an advocate trying to get around it. And the second thing would be exactly this point. I mean, I do think that the idea that, I mean, to Nadine's point, I mean, sure. I mean, there's a tendency to overclassify, and that's why, you might review the 77,000 documents and think, wow, there's only, 1,000 of these, that there's even a remote claim that they actually should be withheld. Out of, 1 out of 77. That's not a great rate, but the point that nobody did that.
Yeah.
And they used a sample size of 2,000 and said, well, close enough for disclosure. I think that's, whether it carries the day or not, I think that's going to be something that's a powerful point that the advocate will be able to make.
But in the end, and this is what we were saying about the Humanitarian Law Project, the real question is who's going to do that? Or is the court going to have any role in doing that? So really the issue is whether there is going to be a complete deference to the executive when it says this is classified, or whether you're going to come into court with the documents and say, here, Judge, either in camera or otherwise, here's why we think it should be classified, and have another person, i.e. a federal judge, looking at it. And that's what was being mightily resisted in the Humanitarian Law Project, and that's what the administration in general mightily resists.
Oh, I don't doubt that. I mean, the thing that makes these cases a little bit different is just, it's no longer the government say so. These documents will be out there, and there'll be a case to be made that certain of them were released that turned out to have serious consequences. And if that case can be made, along with the lack of sort of a professional intermediary and just really nothing more than a conduit, I think that that's something that will at least get some of the justices thinking about this in a different way and thinking this is not just the Pentagon Papers too.
Well, Lee made this comment a couple of times about the court failing to acknowledge and discuss the implications of globalization. Critics, including I think some of your writings, Adam, have pointed out that the court likewise has failed really seriously to come to grips with technological changes, not only the advent of the internet, which it could have dealt with but chose not to in
Oh,
the
no, they're up to
funeral
speed.
process.
Just recently, they decided a case on pagers.
But I do
Which they
think,
didn't understand how they were.
I agree that the court is avoiding dealing with that, and I think one of the cases in point is their punting of the major issue in Doe versus Reed, where the issue is in this new age of internet communication, does disclosure of petition signatories work in the same way? And it's interesting because I think that if Pentagon Papers, manages to, and it'll continue to survive, then the press as an institution will be, I think, standing largely alone in what is a decontextualized First Amendment. Like, I disagree somewhat with Kathleen Sullivan's analysis that this is a move toward libertarianism, because there's always been a tension in the First Amendment. Are we talking about individual expression and autonomy, or are we talking about public discourse? And if you can see one movement in the court, especially from Chief Justice Roberts, you're looking at less of, this is about the speaker's connection to this issue. You especially see this in Citizens United, where it doesn't matter whether there's a speaker. All that matters is that communication is enabled, which will aid public discourse. But I think that you see this also in Doe versus Reed, where Chief Justice Roberts rejects the facial challenge to the disclosure statute, but he does so in a way that tees up the issue for as applied in an interesting way. What he does is he says, well, this isn't the groups there had claimed a harassment exemption that was based on classics such as NAACP versus Alabama, and other group-based harassment. Socialist Workers' Party harassed groups who could reasonably say, look, we as persecuted individuals know that the persecution will increase if certain information is disclosed. But what Chief Justice Roberts says is, well, the fact that this petition is controversial doesn't mean it should apply to all petitions, no matter how run-of-the-mill. How will this play out in terms, and he welcomes an as-applied challenge based on the controversy of the issue, which, if you think about it, could allow a Target corporation to claim the same harassment exemption as a persecuted group of individuals.
I think Monica's quite right that that's one of the next big issues just over the horizon, about whether the claim that I need to be protected, my identity needs to be kept secret in order to protect me from some kind of harassment, And that thing, and Citizens United, of course, they upheld the disclosure requirements.
Yes.
Floyd, what do you think the correct normative answer is on? What's the right way to think about that issue?
I would require a very high level of proof of likely harm, not just feeling bad, but consequences. A burden that the NAACP could meet, obviously, very easily, but I don't think could have been met I think it's unlikely that it could be met by people who sign a petition taking a position on a public issue and then say we'd rather not have our names come out because we might be subjected to pressure or worse. So, I mean, I start out very much with Justice Scalia and what he said in his opinion on this, that, I mean, if you go public on something, you're in the game. It's almost self-defining yourself as a public figure for this issue, with exceptions. But the exceptions I would keep very narrow.
Before we turn to some very good questions, I wanted to ask Lee a question. We've been talking about the First Amendment in the classic sense of protection against the government. But First Amendment values are American values, and putting those into place in private institutions like universities may or may not pose special challenges. I imagine you want to foster both vibrant discourse, but also a space in which people can feel comfortable talking. How do you apply First Amendment values in that private setting?
Now speak clearly, Lee.
I mean, I could be aberrational because of my First Amendment interests. But I actually think that one of the interesting things that's happened in American higher education is that private universities in general follow exactly the same First Amendment responsibilities that public universities would follow. So I think I think it speaks to the power of the First Amendment in society that private universities feel, you know, we gotta live by that too, even though, you know, we could choose otherwise.
So some of these questions are focused on personnel on the court and perhaps clashes between them and perhaps surprising clashes. One of them I'd like to pose to Paul Clement, who clerked for Justice Scalia. Is there an alito doctrine in the First Amendment? If so, is it likely to gain traction on the court? And perhaps let me amplify an aspect of that. What makes for what seems to be an emerging heated difference of opinion between those two justices generally thought to be sympathetic in many cases?
Well, I think, you know, Justice Alito really is kind of marking his own path in the First Amendment area in a way that I think is doctrinally fascinating. And for those of us that, you know, watch the court, I mean, you know, thank goodness there's, you know, some kind of interesting stuff going on.
Bless him.
Yes, no, exactly. And maybe that's why he's doing it, who knows. But I tend to think not. I tend to think that he's tapping into sort of, you know, a small c conservative notion that maybe in certain contexts, you know, we've taken sort of First Amendment principles too far, and that there are sort of countervailing concerns, and, you know, especially in an area like Snyder against Phelps, where, you know, you could have looked at that case. The eight justices didn't, but you could have looked at that case as being not a pure First Amendment case, but being a case about sort of, you know, invasion of privacy. And, you know, it's interesting to me that you have justices like Justice Scalia, who maybe as a matter of, you know, first impression might have had trouble with New York Times v. Sullivan, and, you know, as a matter of first impression might have said, well, what are we doing, sort of constitutionalizing state tort doctrines? But at this point, they're full on board, and doesn't matter sort of how terrible the speech is. They have a very pure First Amendment perspective on this. And, you know, I think in some ways on the First Amendment, you know, Justice Scalia certainly views himself as having a very hawkish pro-First Amendment context. I think for him, as I indicated, I think for him, it really is a threshold question of whether this is a pure First Amendment case or something else. And I think if you can convince Justice Scalia that it's a pure First Amendment case, I mean, he'll be Justice Black. Not Justice Black in Tinker, but Justice Black in most of the other cases where he's saying, look, you know, this is, I don't like people who burn flags. But it's important for us to vindicate that. And I think if you talk to Justice Scalia, that's one of the opinions that he's, sort of in votes that he feels most strongly about. He thinks that was really important. And it's just a guess, but my guess is that Justice Alito would have been with the dissenters in that case. And I think he's really has a very different perspective on, the First Amendment. They also have different perspectives on other issues, and not the least of which is legislative history. I mean, Justice Alito is not on board, Justice Scalia's project of ignoring legislative history. And so there are, some interesting differences emerging. And, I would imagine that, it's one of the things, again, makes watching the court kind of interesting, is that I would think that, President Bush, 43, is pretty happy about the two guys he put on the court. But on a number of issues, there are really important doctrinal differences that emerge from their views of these issues.
Let me just add quickly that I think it's very important, again, in this globalization theme for the United States and for the court to realize that it now no longer only has to persuade American society about what First Amendment should be, but it's got to speak to the world about this, because there is a critique, which I hear frequently, and I think we'll hear more and more, coming from places like China and Singapore, which is the United States, and Europe, which is the United States has taken this principle way too far. You're creating this crude society where you have a dysfunctional political system. You have turned it into sort of rabid opinion against the center is being removed, and this unreasonable commitment to freedom of speech is undermining the very core of the society. Now that is a powerful critique, and I sense some of that actually coming into Alito's opinions, and what I'm waiting for is the powerful answer to that. Why this value and the extent to which we've taken it is actually really good. And that seems to me to be a burden that the majority hasn't reached here.
The next question sort of pivots off this, and let me address it to Nadine, and let me broaden it a little bit. It's focused on fighting words, but I'm interested in incitement also, and I think that's part of what your comment goes to, whether Koran burning here that gives rise to serious and direct violence abroad, whether that's something that American courts ought to be concerned with. But anyway, let me read you the question. In Snyder, Alito's dissent focused on fighting words. A jury verdict that words in fact caused injury seems to clearly fit in fighting words doctrine. Is there anything left of fighting words?
No, fortunately there isn't. Although the Supreme Court again makes life interesting for lawyers and law students and professors alike by not only issuing inconsistent or, let's say, diverse opinions. That's a less stigmatizing term. They keep on the books old decisions that have been inconsistent with decades of subsequent decisions, but never overturn them. Sometimes that makes me very sad when the court pays lip service only, I believe, to the great ACLU victory in Tinker versus Des Moines. Sometimes, even in the Cold War McCarthy cases, the Dennis case has not been overturned by the Supreme Court, in which it upheld the conviction of individuals merely for teaching classic works of Marxist-Lenin doctrine. Same thing in Chaplinsky allows the punishment of a Jehovah's Witness for engaging in political and religious expression directed at a government official, a police officer. It stays on the books and is completely inconsistent with all of the great decisions that Lee referred to starting mostly in the 1960s and 1970s. But I suspect that perhaps the reason that the court leaves those older cases around is because it doesn't want to completely, at least not enough justices want to completely abandon the opportunity to seize upon those limiting doctrines if a current danger presents itself. And if I can say, there's one new doctrine that we didn't refer to expressly. I think Monica referred to it in passing, which I see as another potential weapon for the court to pick up when it wants to allow government suppression of speech, and that's this new government speech doctrine that has cropped up not only in one decision from the Roberts Court, but also one from the Rehnquist Court. and as a number of justices indicated in their individual opinions, can be a vehicle for viewpoint-based discrimination by the government.
Floyd, following up on that a little bit, do you think that American courts need to think differently about incitement given the global nature of communications now?
Well, first of all, I think they may. It was striking to read Justice Breyer saying, with respect to the burning of the Koran in Florida, that he thought that might well pass a clear and present danger test. That is to say, pass being fail, and be unprotected speech.
It might not have been his most considered remark. I think it was on the radio or something.
Didn't he retract it the next day?
Did he retract it?
I think he modified it a little bit.
All
But
right. But as to whether the court should take account of the impact abroad, the idea of expanding the notion of a heckler, and in Pakistan now, murderer's veto, with respect to speech which we would otherwise consider protected under the First Amendment, is just anathema to me. No, I don't think that we should think about things that way. And apropos Lee's point, I understand that you'd like to have a rather eloquent articulation of how we got to where we got, of why we're here. I'm less persuaded than you that we should do it in order to persuade the Chinese.
Yeah, I mean, I think it's unlikely to persuade the Chinese anytime soon. I think, though, we have to realize we are in a context where people are, around the world, are going to be looking for how to fashion a free speech, free press principle, because we have to. That is to say, global communications is making it such that you say something in the United States and you're now subject, as you well know, because you've been involved in this, you're now subject to civil and criminal penalties around the world. And what happened in this country is, as our communication system went from local to national, we had to create something that responded to a national protection. That's going to be much harder to do on a global scale, but at least we ought to be arguing for it and explaining it. So that's my point. I think you're right, Floyd. I mean, it's not a huge thing to think that the Chinese are going to be persuaded. But I do think we have to start thinking of ourselves in a global context.
But the Chinese people may be persuaded, if I can say, starting actually a couple of decades ago, international human rights organizations, which were then grappling with this notion of Asian values that supposedly, I think this is part of what the point that you're making, value order and prosperity and security and other values more than we do. Organizations that I'm familiar with, including Human Rights Watch, did really fascinating and I thought persuasive reports in which they showed that freedom of speech actually promoted all of those other values. This gets to that balancing we were talking about earlier, and conversely, that censorship had been used, including in the former Soviet Union, to repress people's economic survival and prosperity. So one can show that even in service of other values that might be much more at the forefront of people's concerns than abstract freedom of speech for ideas they dislike, that they too depend on the robust concepts that we enjoy here.
The next question is addressed to @Clement, which may be your Twitter handle. And I'm not sure why, because Paul mounted a successful defense of the McCain-Feingold Act, although in other contexts he says he doesn't always agree with the statute he's defending. The question is, the First Amendment is meant to protect, strengthen public discourse. How does treating campaign donations as free speech promote this goal? Allowing the rich an overwhelmingly disproportionate megaphone would seem to defeat that goal.
Well, I really do think, that's probably directed to Floyd, since, we were on the opposite sides of McConnell, so.
I just never knew what you thought.
You never will.
Sides, right?
Look, I have no idea if giving the sort of protection that is afforded in Citizens United is going to promote public discourse or not. It will free public discourse. It will allow things to be said by institutions that could otherwise not be said. My First Amendment tells me that's a good thing, whether or not it turns out to be a great thing in this election or that election, or in terms of whether the level of public discourse is improved or not. I think that the bet that we have made on the First Amendment is that, as a general matter, we would rather run the risks of more speech, even bad or dangerous speech, than of government involvement and certainly government control over that speech.
Can I jump in, Floyd? Because everybody, when they talk about Citizens United, assume whatever corporation they want to hate, right? And it's always a rich, powerful, for-profit corporation. Very rarely is it mentioned that the restrictions apply to unions as well as corporations, that apply to not-for-profit corporations, such as the American Civil Liberties Union, which was there on Floyd's side as co-counsel and party. That it applies to media corporations. Adam, among others, has written about that. So whatever you might think about those big, bad, very rich, very powerful for-profit corporations, this was a law that made it a crime for me when I was president of the ACLU. I faced a 5-year prison sentence if the ACLU did what it had done in the past, which is to take out, as an organization that by its own charter is nonpartisan, never advocates for or against the election of officials. We could not call on President Bush to allow provisions in the Patriot Act to be sunsetted. That would have been a crime. So I would hope that, and I would be surprised, I assume American Constitution Society is also a corporation, right? Most advocacy groups are. At least you would support that aspect in those applications of the Supreme Court decision.
Monica, do you want to say something on this point?
I don't want to, but it seems like I have to. I mean, I think that the question of what sort of corporations should properly be covered by campaign finance restrictions, and whether the other avenues to engage in political advocacy for nonprofit corporations and other corporations who, we think of as who we think of as integral participants in the system is somewhat separate, I think, as Nadine says, from whether for-profit business corporations should be able to use shareholder funds as opposed to voluntary PAC contributions to fund political advocacy. And where you draw that line, I think, is a question for debate. But, I think that the argument that you can separate the baby from the bathwater goes both ways.
The question actually was one step back, and it was really focused on Buckley and money as speech, and nobody seems to be responding to that. And of course, Citizens United just was built on that bridge and made absolutely, it was the assumption and completely unexamined. So I would be interested to know what people think about that.
Well, I think, in the money versus speech context, I mean, Buckley never held directly that money equals speech. It holds that it facilitates speech, but interestingly, it draws a hierarchy between contribution. Well, I can't believe I just prefaced a sentence about the contributions expenditures distinction with the adverb interestingly, but
we share your view.
Exactly. But I think that the idea that the court had in Buckley, which was sort of rejected in Citizens United, is the First Amendment value of a political expenditure is correlated to whether or not the donor intended that to be used for political expression. Now, I mean, you can see that very easily in the case of most direct independent expenditures, and more attenuatedly in the case of contributions. It's hard to see it when you're talking about, the treasury funds of a business corporation.
I'm going to violate my own rule about talking too much about Citizens United and just ask one follow-up. As to the result of the narrow question in the case, which is, should it be a crime for a corporation to spend money to make a documentary about a political candidate and distribute it on video on demand? What's the correct answer to that narrow question?
I don't think it should have been criminalized.
Can I just follow up on that point, which is to say, I mean, I think Judge Berzon made the point about the sort of confusion between facial challenges and as-applied challenges. and maybe this counts as just sort of a disgruntled advocate's point, but I mean, I have to say, of all the cases that begged for an as-applied resolution, it was Citizens United. And of all the cases that didn't, I mean, of all the cases that didn't, it was Wisconsin Right to Life, which I lost twice. But you know, there was a case where you had what I think most people would look at the ad in Wisconsin Right to Life and to say, this is precisely the kind of ad that the Supreme Court was talking about in McConnell when they said that this statute was not facially overbroad. It's in the heartland of the statute. And then you get Citizens United. And I mean, whatever else Congress had in mind, and whatever their motivations, they were not focused on 90-minute documentaries and the advertisements for the 90-minute documentaries. So I think, you know, if you want to put sort of a spotlight on a little bit of disconnect between as-applied and facial challenges, I would put those two cases side by side, and you know, I would challenge anyone, including Floyd, to you know to say that aspect of those decisions kind of makes sense. I think that's a real hard one to square.
I think those doctrines are, shall we say, malleable. But Wisconsin Right to Life is a good example of what this is all about, at least from my perspective. We're going to say it's illegal, a crime, prohibited, unprotected by the First Amendment, to take out an ad criticizing, pressuring a senator for having basically a pro-choice view of life. I mean, it seems to me, and I'm not answering anything Paul
By a
has
grassroots
said.
citizens organization.
I mean, from my perspective, the notion, and I'm arguing now with the McConnell case more than Citizens' Right to Life, I understand, but Wisconsin. But just think of it. I mean, the body of law we had developed, the body of law that Congress had passed, the body of law that the Supreme Court had affirmed, made it a crime for a political group, a one-issue right to life group, to put an ad on television blasting senators, Democratic, liberal senators, who would get a lot of applause in this room because of their view about abortion. It cannot be, I think, cannot be reconciled with the First Amendment to have a system in effect such as that. And I think it was that sort of case which led to the fervor of the five-person majority in the case. Justice Scalia has been referred to, so I'll take the liberty of saying that in a chat long ago that he had with Nadine and myself, long before the Citizens United case, he was vehement in saying that he could hardly imagine a worse First Amendment violation than had been created by the totality of the campaign finance laws.
Let me ask one more question that's unrelated to Citizens United, and mostly because I just want to say the words you'll recognize in here. Lee, how can students exercise their First Amendment rights after the bong hits case? You want to?
I do want to.
I thought we had an understanding.
I do want to make one distinction. If we're going to talk about the facts of Citizens United or the facts of Wisconsin Right to Life, I think that we ought to be clear about the boundaries that were drawn by the statute at issue, because the boundaries were drawn in order to allow, you know, both by the court and by Congress in the MCFL case and in the particular sphere of communications that were prohibited by McCain-Feingold, in order to allow organizations to voice their views. Now, these prohibitions were designed also to try to avoid certain kinds of circumvention in ways that became, unfortunately, very complicated to define as a result of both the case law and Congress. But to say, I think, that this was about keeping grassroots organizations from speaking about a candidate's views is a gross oversimplification of what the statute did and what it was intended to do.
My job is to get you guys out of here on time, but I do want to give Lee one shot at this question, which I kind of like. What's left after bong hits?
Well, I mean, I view,
I think a relaxed feeling, I understand.
what did you say?
All right, well, the
nothing
First
to add.
Amendment, the First Amendment panel ends with speechlessness, which is appropriate in its way. Thank you very much.